Okay, we're going to talk about debtor-creditor rights here. First of all, with respect to creditors, because people lend you money, right? Smart creditors will protect their interest via contract. So if I lend you money, I would want to make sure you obviously can pay the loan. So I may want a cosigner. And your book talks about these sureties and guarantors. Far better to have a surety. Surety is a person that's primarily liable on the loan. Remember we talked about negotiable instruments. The maker is primarily liable. If you have a co-maker, cosigner, they're going to be primarily liable. So sureties are that. Guarantors are fallbacks. Remember, under the statute of frauds, guarantor has to be in writing. But any negotiable instrument has to be in writing. Anyway, so if you're going to do that and you're a creditor, make sure you get a cosigner, and I would put on the contract that their capacity as a surety. A creditor can require certain types of collateral. And we talk about if real property is used as collateral, you hear the term mortgage, right? Often people will say I have a 30-year mortgage. Well, you have a 30-year loan contract to pay off the mortgage, right, the loan. But a mortgage consists really of two documents in common parlance. The mortgage is the loan itself, which is normally a negotiable instrument, right, where you're the maker and of the instrument, and the payee is the lender. Now the payee can transfer that, etc., via negotiation or assignment. That's where real property is collateral, has to be in writing pursuant to the statute of frauds, right? Now, in our state, we refer to deeds of trust as it's a three-party arrangement where, in theory, a trustee is holding the deed in theory, and if you don't pay the bank notifies the trustee, and the trustee then begins a non-judicial process to foreclose. So foreclosure is the right term used if you don't pay off your real property loan, your mortgage loan. So you foreclose on real property, right? You don't repossess real property, because in theory you own the property, the real property. So foreclosure is the right term. And foreclosure can occur both judicially. The lender can go to the bank and start a foreclosure action, or they can do it non-judicially through the trustee in the deed of trust statute. Now there are a number of ways to avoid foreclosure. Your book talks about this. You try to work out a modification. Short sales are very common. The dilemma there is that the bank allows you, the bank has to agree to this. If the bank allows you to sell the property for maybe what you owe on it, even though the property or the value of the property, you're underwater, let's say, and you have a $500,000 loan, the property is only worth $250,000. You sell the property for $250,000, you could still be liable for the deficit on that, personally liable. So you got to be very careful with short sales to make sure you're not liable for the deficit or the deficiency. Other way is deed in lieu. This is very rare. The banks have to agree to accept your deed back in lieu of a foreclosure. Very rare opportunity, thing to happen. Some people do what are called strategic defaults. They stay in the house, wait for the bank to foreclose, and then they leave. That's real risky because you're still liable on the loan, but it may make sense to stay there rather than and save your money and then move on. That's called strategic default. You can Google that or Bing it and look up more on that. So that's where real property is used as the collateral to secure the loan. That's a mortgage. Now personal property can be used as collateral to secure a loan with creditors. And this falls under the concept of secured transactions. Now the UCC Article 9 is the law that talks about this, but again, it's a default based on what your loan agreement is. So a secured transaction You have personal property, can be tangible or intangible, is used as collateral to secure the loan. So you could have accounts receivables as the collateral. And you'll see it with a secured transaction. It's much like a mortgage in the sense that there are two documents at least normally. As we discussed with a mortgage, you have the loan itself, and then you have the deed itself, where you record the mortgage or the deed. So with a mortgage, you have two documents, a loan and the mortgage that you've recorded, or the deed of trust. Then with a secured transaction, you have normally a contract, a loan agreement, and you have some way of perfecting that. And what do I mean by perfection? That's the idea of notify the world that, hey, I have some rights in this collateral. And you'll see this discussion in your book. It depends on whether the type of collateral that you're talking about. But a typical scenario is that you'll have a loan agreement that'll describe the name of the debtor, describe the collateral. This will be then filed with the state as under the UCC Article 1 form filing in the state of Washington. Department of Licensing is where you file it, which is kind of unusual. Some states it's the Secretary of State's office. So you file this, and the idea is that it's just a notification that you have priority over that collateral. Likewise, with real property, you would normally record your mortgage to give you priority over any subsequent credit. It's smart to do that, but not mandatory. There are 5 stages of a secured transaction. You'll see there's a useful video on this from Professor Ali Khan at Washburn University. And he uses the acronym CRAPPS, CRAPS, that's what he says. The creation of the security instrument, attachment, which is basically the contract, perfection, which can occur in different ways depending on the nature of the personal property. If you're a pawnbroker, perfection occurs by taking possession. You also have perfection by filing a UCC 1 statement. So that's perfection. Priority obviously is first. Normally the first to perfect gets priority. One major exception is purchase money security interest, where a lender lends you money to buy a particular piece of equipment. They will normally take priority, even if someone else has a blanket security agreement covering all inventory or all equipment. So, it gets a little nuanced, a little complicated. Just be aware that of these 5 stages of a secured transaction and why they're important for businesses. Obviously, creditors can also put liens on property. Your book talks about mechanics liens. That's kind of a misnomer. This is where somebody did some work on your real property. You didn't pay them. It could be a subcontractor. They can go through a statutory process that require notices and put a lien on your property. If you don't pay them, they'll foreclose on it. Artisan lien is somebody who did work on personal property. You didn't pay them. You took your car into a shop. They put an engine in there. You didn't pay them. They can hold your car, and that's referred to as an artisan lien. Judicial liens, obviously, somebody's gone to court, creditors gone to court, got a judgment, and I think it's important to understand the fact you get a judgment doesn't mean you're going to get paid. So you've got to go through a collection process, which is very painful for everybody involved. And this can include things like attachment of property. This can occur before you get a judgment. Before the creditor gets a judgment against you, they can seize your bank account, attach it. They have to put up a bond normally. And if you lose the case, they can have that executed on, can basically have the sheriff acquire that bank account or any other property. So attachment and execution, very painful process. Garnishment, this is very common, but employers don't like it, quite frankly, because they are caught in the middle. This is where normally with employers, but could be anybody else holding an asset for you, like a bank, where the creditor goes through a statutory process which involves a writ of garnishment, and they execute on that writ by having your employer deduct money from your paycheck, etc. So very common for people that don't pay their child support and things like that. Again, there's a difference with personal property. If you don't pay on the secured transaction or your car loan, I should say, then it's going to be repossessed. That's where you get somebody coming out and towing your car away, and that because you're not really the owner. The lien holder has a right to take and repossess your car. Foreclosure is what the term used for real property. Now for debtors, you're not totally out of luck. There's a lot of laws that protect debtors. And you'll see these discussed in your book. One in particular, the Fair Debt Collection Practices Act. This limits what collection agencies can do, call you at odd times, contact your employer, things like that. Take a look at that. I think there are limits. It's not an absolute prohibition, but you have rights, and it's important to understand those rights. And try to work out a deal before the attorneys get involved. Once the attorneys are involved, collection attorneys, they're going to take its cost escalate. So it's best to work out a deal as soon as possible with the creditor before it gets into collection agency hands, and certainly before the attorneys get involved. Finally, at the end of the rainbow is that debtors have a right to file bankruptcy. Now, there are different types of bankruptcy. This is an area where you should talk to an attorney or at least be aware of your rights, because oftentimes people do stupid things that are they inflict harm upon themselves because they don't understand how bankruptcy works. But generally, here's the deal. You file a petition. This is normally done online. This will stay collection activities. Now, if you have a asset, a home that has a mortgage with a secured creditor, again, this gets back to why it's important for a creditor to be a secured creditor, whether it's on real or personal property. If you have a home loan, that secured creditor, that bank will go to the court and get a relief of stay and foreclose on your house. Not on you personally, but they'll grab the house. Now, you can reaffirm the debt. You'll see that's discussed if you want to stay in the house. Likewise, with personal property, your car. If you have a car loan, you declare bankruptcy, you don't get to keep the car. The creditor is going to go to the court, get a relief of stay, and repo your car. And if you want to keep your car, you can reaffirm the debt. There's a process to do that. There's two different types of bankruptcy discussed in your book. Liquidation, which is Chapter 7, applies to both businesses and individuals. And this is where financially as an individual you fall under certain financial threshold that allows you to go through liquidation. The other type is called reorganization. Chapter 11 is for business, Chapter 13 for wage earners. I should say there are numerous exceptions or exemptions to bankruptcy. What I mean by that is stuff you can keep. There's a federal list of exemptions, then states have adopted, most states have adopted exemptions, again, stuff you can keep. For example, in some states, if you own your property, own your home, and have no mortgage, you can keep your home regardless of the value of the home. Your unsecured creditors can't force you to sell the home. There's homestead exemptions of a certain value of their home. If your home is under a certain value, like the state of Washington, $125,000, you can keep your house, assuming there's no secured creditor on the house. Jewelry, up to a certain amount, car value up to a certain amount, equipment, stuff like that. It's a whole laundry list. Big ones are like retirement funds. You can keep that, so you'd be an idiot to liquidate your retirement if you can keep it. In bankruptcy, I should say, the things that are discharged are unsecured creditors, especially under Chapter 7. Credit cards are unsecured. So if you file bankruptcy in your Chapter 7, you would normally be able to wipe out your credit card debt. So if you are dealing with a limited amount of money and you're looking to go down bankruptcy road, it would be foolish to pay off your credit cards when there are other debts that you cannot get rid of, like your student loan. Generally, you cannot get rid of your student loan. There are exceptions, hardship discharge, and the government has certain payment plans based on the income, but you have to affirmatively choose those plans. There are links on your course page about these options. I would encourage you to take a look at those, because the biggest debt most people have these days are student loans.